Guys, tonight we have a great group of people together, and we're just going to try to answer some questions and kind of talk through some of the information that we feel has been left out. There's a lot of questions out there from supporters, and we just want to discuss with some of the legal team. We've got Morgan Philpot on the line, we've got John Lamb and Rick Koerber, as well as myself, Kelli Stewart. And so our goal in this is just to really help people kind of understand what could be to come now, based on the hung jury and guilty verdicts that we received today for Greg Burleson and Todd Engel, and hope we can just clear up some things and maybe give people a good fresh start and give some hope, looking forward to the next trial. So with that, John, do you want to start with maybe questions that you've seen people ask today regarding the verdicts?
Yeah, so I guess there's several that came up today concerning this mistrial and guilty verdicts. And some people were asking, since it was a mistrial, how can they continue with guilty verdicts in the same trial and go ahead and charge people or to have a new trial for them on this mistrial but leave the guilty verdicts? How is that actually a retrial? Are they just retrying them only on the hung jury part?
Yeah.
Or are they going to, yes, is that?
Yeah. So hung jury mistrial, generally the same thing. And what it means, John, is, this was handled a little bit unusually compared to what you might normally expect in terms of how the jury came back after this 3-day weekend and then said, hey, we're hung, but we've got some partial agreement. And then the judge basically brought him in and had him deliver that verdict on those 10 counts, and then sent him back with some instruction on seeing if they could continue to deliberate, but not on those counts. So the way that happened was a little unusual, but the general nature of what happened is very typical, and you basically have to view each charge and each verdict as its own kind of animal. And so what the judge did is the judge basically allowed the jury to return the verdicts on those 10 counts that you were reporting on earlier today, and then there's a mistrial or a hung jury on the rest. And what that means is that unless there's a double jeopardy issues that would attach, and generally speaking, based on what happened today, that would be very unusual. I know there are some tangential arguments out there about why double jeopardy might have attached, and we can talk about that too. But generally what it means is the prosecutors now have the option to retry all of these defendants that were in this first trial on the charges where a jury didn't come back with a verdict. There is not going to be a new trial or a retrial on the 10 counts where there was a verdict. Now,
I guess what was concerning to some people is that one defendant, Greg Burleson, he received 8 charges, but now he was not found guilty of the conspiracy. So if they brought him back in with these other defendants and were only trying him on the conspiracy charge, it would look somewhat odd that he wasn't getting any other gun charges or nothing like that to a new jurors.
Yeah, and there's all kinds of considerations now in terms of how the court will proceed, and it's not at all certain what's going to happen. You've read some media accounts and you've heard things, but it is not at all clear how the court's going to decide to proceed. The parties are all going to have to weigh in on this. I know there was some discussion already about the parties. I know Pete Santilli has filed a motion with the court to consolidate, because he's saying, hey, if you're going to schedule a retrial of these defendants on the same day that I'm scheduled to go to trial, I don't want to get bumped down the road, and so I want you to rejoin me with them. I haven't read that motion. I just saw that it was filed. So there's really a couple questions, John. The first question is the government in fact going to move forward with retrying these individuals? It looks like they made a preliminary representation, at least, that they want the option to do that, and that's how that scheduling came about. But they don't have to. I would not be surprised that they did, and it looks like that's what they're going to do. But but it's really the prosecutor's discretion at this point. And then the next issue is scheduling. And if you remember, there was a big debate several months ago about how to bring all of these defendants to trial. And, the government had kind of proposed, after months and months and months of saying it was going to bring everybody to trial together, the government proposed these 3 tiers, and the defendants opposed those and said, no, don't make us all wait in jail forever while you do this for this exact kind of situation. And the judge overruled those arguments and those objections and set these 3 tiers and said, we're not going to have a trial with all these defendants. And so, the question now is the judge going to add the retrial defendants to the next tier, do them all together? Is the judge going to bump the tier 1 people now so that these people can have, the tier 2 people can have the retrial? Or, how is that going to play out? And there's going to be some motion practice. There's going to be a hearing that's currently scheduled in May. And some of that, it's a moving target. And I wouldn't be surprised if there were some developments on that in the weeks ahead, because there's going to be several people making arguments about how this should go forward.
So what you're saying then is that they can in fact retry Todd Engel and all the other counts minus the 2 he was found guilty on?
That's right. That's right. Now, there's an argument that, I know there's a philosophical argument. Some people say they shouldn't be allowed to, but yes, it's the way the law is now and the way the law in these situations has been for a long time. Whether it should be that way or not, yes, absolutely they can retry them. Again, there's always arguments. Clever attorneys and clever defendants do come up with arguments, but there doesn't seem to be any obvious reason why the law wouldn't allow them to be retried. And here's why. The basic double jeopardy issue that people always want to bring up is the jury didn't make any conclusions about the facts of these other charges. So they're not, it's almost like it would almost be like the new trial is a continuation of the first trial with new jurors. And I know that's not a perfect analogy, but the question's still open. The jurors didn't answer the question, and so it's still an open question.
But isn't it true that they did 10-2 on all the other counts, except for Eric Parker, who was 7-5? They did in fact answer the question. So essentially what you're saying is if we could have combined 2 juries together, taken all of them that either agreed or disagreed, separated them into 2 juries, we would have one whole jury that was a not guilty and one whole jury that was guilty.
It's very interesting. In a civil case, you don't have to have unanimous verdicts, and so you can mix and match sometimes, and you can see things like that. But in a criminal case, there is no decision unless it's unanimous, and it doesn't matter whether it's 10-2 or 1-11 or 11-1. I mean, it matters. It's informative, and I think it's helpful to the defense to see that even given a lot of the dissatisfaction that the defense team had in terms of how this trial was allowed to proceed and what was excluded from the trial and what wasn't allowed to be presented, I think there's some good information that can be learned by the defense, and I think there's some encouragement that there were these reportedly jury decision splits that were in favor of acquittal by a majority, if you will, but it doesn't matter. If it's not unanimous, there's no decision.
Do you guys, from a legal standpoint, consider today a win for all of the undecided charges? Would you rather have what happened today versus a guilty verdict?
Morgan, you better weigh in on that one.
Well, I would say, of course, I'd rather have what happened today than a guilty verdict. The only worry or concern that I have is the government getting multiple shots at attempting to prosecute people. But, from the other angle, we also get to watch what they did and prepare for the next trial. Yeah. So yes.
Sorry not to talk over you, Morgan, but Kelli, you and I talked earlier today. One of the interesting things, and it's so much happens in these situations, and there's so many different perspectives. something that's hard to grab the broad perspective. But remember this. Remember a lot of the things that happened at this trial that the defense did not know before this trial, that the defense now gets to use going forward. And there's a lot that the defense did not know, that the government, for whatever reason, had not been completely transparent with. For example, whether Greg was an informant or not, and how that all came down, and the issues with Dan Love. I know, that was a big deal with Special Agent Dan Love not being able to be called by the defense when they wanted to bring him in. The defense gets a second whack at this too, in terms of now seeing how the cards fell, and the judge does too. The judge gets a chance to look at the situation now and make different decisions. So, it's interesting. There's a lot of philosophical debate to have about whether it should happen the way it's happening, but here's what I think the moral of the story is, and that is there's a long road ahead here. There's still a long fight.
Is there any chance of getting a different judge for the remaining trials?
Well, there's always a chance. It's not likely. I have, we got to be careful. We can't get into specific trial strategy, but there is a chance. One argument would be that perhaps another judge could handle one of the trials, and then these defendants wouldn't all have to stay queued up in a line like that. But at this point, we're just reading tea leaves. There's a chance, but as of right now, no. But there could be some developments that open that door up.
What about speedy trial? Are we? Do we have anything like that? Are we violating any of these guys' rights on speedy trial?
Yeah. And by the way, just so everybody knows, one of the reasons I'm jumping in is Morgan's an attorney on the case. Morgan's a little bit more limited just by the rules on how deep he can go into some of these conversations. So, John, remember, a speedy trial is a big deal in two different ways. Under the Sixth Amendment to the Constitution, that amendment protects our general right to be brought to trial under certain conditions, and that includes the right to a speedy trial. For a long time, a lot of people in this country were oppressed in the federal and state courts because speedy trial started to mean 1 year, 2 years, 3 years, 4 years, 5 years, etc. And in the 1970s, Congress passed a law called the Speedy Trial Act that also outlines some specific parameters for a speedy trial. So when you ask the question, what about speedy trial rights? There are two kinds of rights at issue here. There are constitutionally protected rights, which would be like a big circle, and then within that circle, there's statutorily protected speedy trial rights, which is a smaller circle. And under the Speedy Trial Act, that smaller circle, the government has 70 days to bring a defendant to trial, generally from the time they're arraigned and they plead not guilty. And that's called the speedy trial clock. And those 70 days tick. And if those 70 days expire, the statute requires a dismissal. Now, there are exceptions. There are days that get excluded from that speedy trial calendar. There are days that get excluded, for example, when a defendant or the government files a motion. Once that motion's filed until it's resolved, and maybe 30 days after that, there's a certain block of time that doesn't count because you have a right to a speedy trial and a fair trial. In other words, it's not supposed to be a double-edged sword. If a defendant needs to file a motion to make sure the trial's more fair, make sure evidence should be excluded or whatever, that time doesn't tick on the 70 days, neither does it for the government. But the answer to your question is, a lot of these defendants have been raising speedy trial issues from the very beginning, both Speedy Trial Act issues and Sixth Amendment speedy trial issues. And the fact that these guys have all been incarcerated, and the fact that it has now gone more than a year under the Sixth Amendment, that creates what the Supreme Court has called a presumption of prejudice, that something's wrong. And so the court is required to look more diligently at a potential speedy trial violation. So, yeah, there are potential new implications for a speedy trial if the other tiers that don't get to go to trial now because of this mistrial, they have to wait longer. It does open up concerns for a speedy trial. Yeah. But as with all things, the defendants and their attorneys have to make these arguments, and it's hard, right? Because they're going to be getting ready for another trial, and yet you've got to have the ability to sit down and write an argument and cite the law and calculate the days and explain why this day is excluded and that day is not excluded. And people, it is a hard, like a football game. A lot of strategy, lots of choices. Which plays do you call? Which plays do you not call? Which penalties do you complain about? Which ones do you just let go by because you can't argue every single thing that you think is wrong? You wear yourself out. So, but yeah, in answer to your question, definitely this does raise some speedy trial questions.
I'm not sure if either of you guys can answer this or not, but or if you're willing to. What is the difference if somebody has a court-appointed attorney or a hired law firm that comes in that they've paid for out of pocket? What is the difference in representation? Some people are saying, what does it matter if we have a hired outsourced law firm coming in versus the public defenders? They're all just going to defend, the clients the same at the end of the day. How important is it that we have some better representation in this next trial, in your opinion?
You want me
Can you
to
answer that?
You want me to pipe in on that one first, Rick?
Yeah.
So
you're the expensive. You're the hired gun, man. You're the expensive one in this group.
Well, it's also a little bit of a political question.
Hey, sorry, my talk is going to give you the Westminster chimes here for a minute. Apologize for that.
Give them a minute to
That's
think.
right. It's just background music. Well, that gets a little louder there than I thought. All right, so if you go back and take a look at Oregon was a case in which every attorney was a public defender. Now, interestingly, Oregon has a pretty good public defender's office or federal defender's office, and a lot of the attorneys that we got to work with in Oregon were fantastic attorneys. A lot of people remember Matt Schindler's wonderful closing argument in that trial and his general demeanor in the courtroom, which was fantastic and I think endearing to the jury. Bob Salisbury, who was excellent at jury selection. And so it can be a little bit hit or miss. I think one of the main differences is that the client doesn't get to select their attorney. And that's important because what are the chances that your attorney, if you don't get to select them, is going to truly understand the case from your perspective? In other words, an attorney might know how to fight the government, so to speak, but do they know how to defend you? Do they understand your case? Do they understand why you did what you did? And can they look at it from an angle not just of that of kind of an unbiased federal defender perspective, but from the perspective of an attorney who you've selected as a client, who understands your case and has a better idea, I think, how to fight not just the argument the federal government's going to make, but how to defend your actions from your perspective and perhaps from a Western lands perspective in this case.
And let me also chime in on that, because I know there's some things that Morgan probably, as an attorney, he's going to look at it a little bit differently. Having been a criminal defendant and being a criminal defendant, I think it changes your perspective. The general rule, Kelli, is if you pay for your own attorney, you get to choose your own attorney. If you don't, you are entitled to constitutionally minimum standards of legal defense. And what that can mean is a big deal. For example, a publicly funded attorney can't just spend resources on everything you want to spend money on, because their budget is scrutinized. So you might want to file a motion to challenge the jurisdiction of the court, and you might be convinced that that's the best argument, but the attorney's looking at their budget saying, here's how much money, you know, as a federally defended or as a federally funded attorney I've got, you know, I can submit a budget, here's what I got. I can't do that. I've got to make a decision. That's not going to, you know, now if an attorney thinks it's a good motion, you know, they're obviously going to go and ask for that budget to make sure they've got the time and authorization. Maybe you want an expert witness and you can't get it because you can't convince the court to budget that money. And so there are restrictions on federally funded defense attorneys, no matter how good they are. And the other thing, and this goes unspoken a little bit, there's a federal defender's office, and they can usually only represent one defendant at a time. And so then there's what's called the CJA panel. There's a law Congress passed called the Criminal Justice Act, where they bring in other private attorneys that don't generally work for the federal defender's office. This is what Morgan was referencing up in Oregon, where they're part of the CJA bar, if you will, and they get called on to come in, and they're paid for by the federal government, but they're private attorneys, but they're on that CJA panel. Now, one of the challenges you've got is, and just speaking candidly, and this is true, what happened up in Oregon, you had Marcus Mumford and you had Morgan Philpot, who were the only privately retained attorneys up in Oregon, and they were also both with law practices that were predominantly not in Oregon. So quite frankly, they're not worrying about, man, I've got to be right back in front of the court tomorrow with a different client. I really don't want to risk ticking this judge off today. Or, God, I've got this prosecutor on another case and I'm working on a negotiation with them. And so there's some tempering that goes on that sometimes is healthy, but sometimes is not healthy. Because especially in high-profile cases, really tense, like political cases like this case, a defendant wants an attorney who's going to go in there and give it everything they got and leave it all on the floor and not be worried. Oh, geez, if I fight too aggressively today, maybe it hurts my legal practice with these other defendants. So a lot of times attorneys who are paid for by the federal government, they feel limited and they feel restricted. A lot of times clients feel like those attorneys are limited or restricted. Although it's a great blessing in our system that defendants who can't afford criminal defense attorneys are guaranteed them, there are differences, and sometimes those differences are hard to swallow.
So let me ask you this then regarding, since you brought up the Oregon case, the Oregon case is a whole team of people working for that not guilty verdict. But we saw, the main face that we saw in Oregon predominantly was Marcus Mumford. How much of a team effort did you guys contribute to that not guilty verdict? I know a lot went into the verdict as far as filings and motions and questions to the jury, or I'm sorry, questions to the defendants when they were on the stand. Who did all that, and how important is it for Ammon now that you guys are back in Nevada with him versus, you know, just his public defender? What are you guys going to bring to Nevada? What did you
Morgan, you need to chime in on this one, but let me just lay the groundwork. I said, you know, Dan Hill's a fine attorney. Dan has been on Ammon's case as a CJA attorney from the beginning. We have a close relationship with Dan. We've been talking with Dan for a long time. And so, you know, this is a little different than Oregon because, you know, frankly, you know, no American, you know, statistically speaking, no American can afford 2 federal criminal prosecutions. They just can't. I mean, most people can't afford 1 federal criminal prosecution. It costs, for the kind of defense that these defendants are looking at, it costs more money than the average American makes in several years to really put on a defense, let alone 2. So the Bundys have all been put in a very difficult situation. And a lot of the other defendants, too, who are defendants in both Oregon and Nevada, it's hard enough to have to put on a defense once. So anyway, I just wanted to just start off by saying it's a little bit different because Dan has been part of the CJA panel, and he's been representing Ammon and fighting for Ammon since the Nevada case started. And Morgan just got admitted what's called pro hoc vice, which means for this instance or for this case, on Ammon's behalf just recently. And so, Morgan, I'll let you chime in now and explain what you're doing and why and the teamwork issue, but I just wanted to lay that groundwork so people understood.
Well, it's hard to know where to begin on this because it's a broad topic. But first of all, if you look at both cases, I think what we bring to the table and what we brought to the table in Oregon, what I think we'll bring to the table in Nevada is a defense, a theory of the case, so to speak, for Ammon. Why did Ammon do, if anything, what he did? Why was he in Nevada? How does that relate to an overall theme that we bring to the table as a defense team? If you go back to Oregon, for example, and talk about what happened in Oregon, how did we get to a not guilty verdict in Oregon, then I think you have to talk about what was the theory of the case. And in Oregon, it was an adverse possession theory or an adverse possession defense, which of course the judge wanted to cut off right from the beginning. What she couldn't do, on the other hand, is she couldn't cut off Ammon's ability to express his subjective intent, so to speak. Why did Ammon do what he did? And in Oregon, that theory was adverse possession.
And it wasn't popular. It wasn't
not
the judge who wanted to kill that theory from the beginning. It wasn't just the prosecution who wanted to kill that theory. We weren't the most popular defense team in some circles because people didn't like it.
Yeah.
No, not only that, I think it without trying to point any fingers, but I think it actually drove some people away from a more collective defense approach. And I think that there's some deep regrets for not having stuck that theory out or not having joined in that theory, because it was a great theory for our case. And it was true. I mean, it was substantiated by the evidence. It was recited by jurors after the case was over. There have been journalists who have contacted us about conversations with jurors and how they couldn't stop talking about adverse possession. And so there's a lot that goes into bringing a case to trial. And often what you get to see kind of voices play out in a courtroom, but behind those spoken words are hours upon days upon months of strategy that goes into jury selection, questions for witnesses, review of discovery, opening and closing arguments. And I think that kind of strategy is what we'll bring to the team in Nevada, just like we did in Oregon. And I think we saw some really fantastic results in Oregon. And I think you can pinpoint specifically in Oregon that a lot of that success in the courtroom came from the theory and strategy, specifically in that case, adverse possession.
You've got to fight. You know, Marcus Mumford has what he calls kind of the Mumford School of Law. And, last I checked, it didn't include being willing to get tased for your clients. He might have to add an appendix to that. But one of the things Marcus Mumford was really good at is carrying out and executing that strategy is a jury has to see that this isn't just Marcus Mumford. There's another defense attorney who's really famous called Jerry Spence, and he does some legal training. He's a very, very well-known criminal defense attorney. And there's lots of different styles and lots of different theories about what a criminal defense attorney is even supposed to do. But what Mumford executed and the strategy that Morgan and I laid as the groundwork when Mumford even walked in to, Mumford was like our A-list, sports athlete to come in and execute that strategy. But here's the idea. The jury's got to see that attorney believes that their client is worth fighting for. Because the jury sits in a courtroom that's owned by the federal government, receives instructions from a judge who has respect and aura and authority that goes with the Constitution under the Article 3 of the Constitution of the United States, that, you know, that juror's a little intimidated. And then there's these prosecutors who are in courtroom every day, all the time, often knows the judges, often knows the court clerks, and they're talking, they usually sit closest to the jury, and they're very comfortable, and usually there's a whole army of them, 2 or 3 or 5 of them. And so the jury is just literally enmeshed with the government's perspective. And oftentimes, it's only the defense attorney who can stand alone and say, hey, we need to interrupt that kind of presumption or that appearance, and we need you to see this defendant and why we're fighting for them. And you've got to kind of almost give the jury permission to be curious and say, wow. And I'll give you an example from my own experience, Kelly. As some of the people know, I've been battling the federal government in a criminal context for years and years. And when I was first indicted, you know, it's life-changing, and it's psychologically hard to deal with. And even my own mother, who loves me more than air, said to me something really interesting. She said, this was early on, you know, this is 9 years ago. She said, but son, you must have done something wrong, or you wouldn't be in this situation. And it broke my heart. This is my mother, who has been in government, who's intelligent, one of the most intelligent women I've ever seen, high IQ, very passionate, loves this country. And I was so offended. I said, you're right, Mother. We should get rid of the whole jury trial system, because every defendant's guilty of something. We should just kind of get on with it. And it kind of shocked her, and she stopped and she goes, that's not what I meant. And that's what you have to break, because even the jury starts to think in the beginning, well, these guys must have done something wrong, or we wouldn't be here. And then the government speaks first in opening argument. The government gets to put on their case first with their witnesses. Then after the defense puts on their case, the government gets a rebuttal case. And then the government gets to speak first in closing arguments. And the government gets to speak last in the rebuttal closing arguments. And so one of the big differences is you have to, if you're not going to plea bargain, and you really want to fight for not guilty, and it's not just because, you know, you're guilty and you got nothing else to lose. I mean, if you're innocent and you want to fight for your innocence and you want to stand up and fight, you've got to have an attorney who's willing to stand up too and say, hey, the fact that we're here and we're innocent means you need to pay attention, because this could be you. And that's where rights come in. You know, everybody's so cavalier by saying, you know, innocent till proven guilty and double jeopardy and all these things. But when your life is hanging in the balance, you've got to be able to say to that jury, hey, wake up for a minute. Hey, excuse me. Please connect here. And that's what I think also a privately retained attorney sometimes isn't as tired, sometimes isn't as overworked by other cases, and so they wear themselves out and they overwork themselves focused on the case they're dealing with. That's not always the case, but I think that's sometimes the benefit of having a private attorney involved. And here, Ammon hopefully gets to have some of the benefit of having both Dan on his case and having Morgan. And people don't know this, and I know Morgan wouldn't say this, but Morgan is appearing without being retained and paid, meaning the money that goes to Morgan is only from donations. And that's, I know that's sometimes an awkward subject for people, but I want you to know the kind of attorney Morgan is and the kind of man he is. And I'm not saying there aren't other great men and women fighting for these defendants, because there are, but that's also sometimes a difference. Sometimes private attorneys come because they're involved intellectually, emotionally, spiritually in the fight. And they want to fight because it's the right fight.
Yeah. So let me ask you this, and thank you for sharing all that, Rick. And I'd love to go into detail more later and give you an opportunity maybe in the next conversation to share about your own trials in this, because I think they're very impactful for people to understand that you don't realize it's going to be you until it's you. And you wish everybody was standing up fighting the good fight. You made a comment, though, that, you know, Marcus Mumford in that was kind of the main player that played, you know, took your guys' ideas and carried them out. how effective, Morgan, are you going to be in Nevada without Marcus? I know that's questions that other supporters have had. He was the front liner on the main defense in Oregon. Are you going to be able to be a bulldog in the courtroom and deal with Judge Navarro, because she is a whole new ballgame. She is nothing like Judge Brown. You know, how's that going to play in without your front runner?
Boy, I think she might be a little bit more like Judge Brown than people suspect. I've been before her, and I noticed a similar demeanor, a similar desire for a certain level of decorum and what's the other word? Probably process, right? Desire for process. And that I can actually respect. I'm not Marcus Mumford. There is only one Marcus Mumford. And that guy will live in infamy as the attorney willing to get tased for his client. And I think we would all acknowledge we wish that we could bring Marcus with us to Nevada, but I don't think they'll let him come. And so it's not an option for us at this point in time. And I don't think it's going to be an option in the future. Because of his advocacy, which was fantastic in Oregon. And so I'm going to bring my own unique style, along with Dan Hill, along with our entire legal team to Nevada, and we're going to give Ammon everything we have. I think one thing you need to understand about me is I have been involved in not only legal battles surrounding constitutional and civil rights issues for as long as I possibly could, but I've been involved politically and as an activist for probably, almost 18 years now, and have been almost constantly involved with Western land issues, constitutional law. As a law student, I actually selected a law school where I could go and learn from Robert Bork, who was one of my professors. So my conviction for these issues runs very deep. My knowledge of these issues runs very deep. And I think what you'll see from me is probably a very different style from Marcus Mumford, but no less conviction and no less of an absolute fight to the very end on behalf of Ammon, my client.
I believe you on that, Morgan.
I have a question to kind of throw out there, maybe for Morgan or whoever here, but how important or how much in the way do people like Kelli, Stewart, or myself get in the way of procedures as being court reporters or court observers and protesters out front? Are we given a plus, or sometimes a
Yes.
Well, if the response that you get from Homeland Security and Metro Police is any indication, and snipers and helicopters, you guys must be doing something either terribly wrong or terribly right. I love you there. I can't tell you what a great experience just Oregon was to walk into the courtroom every day and see good old David Zion Brugger out front, and hear the shofar on occasion and see the barbecues across the street. It was so wonderful to come out after the trial in Oregon was over and to see you guys actually barbecuing with one of the alternate jurors. So, I think everybody unequivocally loves you guys, even those who are supposed to watch you in case you decide to do something absolutely uncharacteristic, which is, maybe barbecue on the front steps of the federal courthouse.
Yeah, I second that. You guys perform an invaluable service. In this day and age, I mean, John, I saw on your video today when we were waiting for the verdict, I don't know how many people were waiting live on every breath that you took But then if you look at the video watched afterwards, I mean, tens of thousands of people. And you have more people watching you than watch my hometown TV news. And so you're doing a good job. You're doing, and the sad truth is, and you guys actually reference this a little bit, there are a lot of defendants who don't have anybody who are making awareness. And so this case becomes bigger than just Ammon Bundy and Cliven Bundy and Ryan Payne and Pete Santilli and all the others, because it's symbolic, and the effort you're putting forward isn't just on behalf of these guys. It's on behalf of our belief in a certain vision for free society and a certain vision for America. And in 2017, that's where the weight rests on shoulders like Kelli Stewart and John Lamb, because you're telling a story that I don't know where else people could go to hear it. It's not like the defense team has time every day to hang out with you guys and philosophize on. I mean, look, it's 1 o'clock in the morning. I mean, where I'm at, it's 1:30 in the morning. And when you're in the thick of things, they just don't have time. And the commitment you guys have made, you are doing a service to the cause of liberty. And there's no doubt about it. Don't let anybody tell you that there aren't people out here that are watching what you're doing. We don't always have time to pat you on the back, but you're creating a tremendous amount of value, both of you.
Let me be the first to say that I predict a reality TV show for at least one of you after all this is over.
Oh, jeez. Can you imagine, John?
It's like a new political, legal version of Duck Dynasty or something.
That's right. Pom-pom Patriots and Lambo.
I will say one other thing, you guys. I know I've been talking a lot, and quite frankly, I got a lot of pent-up energy on this, because one of the other things that happens is this is such a frustrating process because the average American doesn't understand it. Even really intelligent people who read the Constitution and know something about our laws and our rights, until you've been in this world, everything seems unfair, and it's easy to lose hope, it's easy to lose faith, it's easy to get angry, it's easy to get discouraged, and we are in trouble, obviously, in our country. We have got, the heavy-handed tyranny pushing down in so many areas of our government, and that's not rhetoric, that's not hyperbole, but I will tell you, here's the upside. The courtroom is the last place in our government that one individual can stand against the whole federal government. And that's what these men today were doing, and all during this first trial. And the average member of the public doesn't remember their names, doesn't know their names. That's what the Bundy family's doing. And don't downplay the significance that at this late hour, in this great time of trouble in our country, where freedom and liberty and the principles of Constitution are clearly hanging by a thread. Clearly, I mean, it's not debatable. There are judges on the Ninth Circuit Court of Appeals that have publicly said they think studying the Constitution is a waste of time. I mean, we are in so much trouble. But the beauty of our system that was built by our founders is it has weathered even that storm, so that even though you might feel like the playing field's completely tilted against these defendants, even though you might be completely frustrated, your support matters, your support makes a difference, and anything you can do to help these people put on a defense. Most people don't even defend themselves. Most people just plea bargain, good people. And here we have opportunity to stand up with one person, one at a time. Each of these individual people, each of their lives is literally being offered in a way as a defense for all of us. And so what you do is a part of that, and what you guys are supporting is a part of that. And I know it's easy to get discouraged, but look what happened when we won in Oregon. Nobody thought we were going to win in Oregon. Members of the defense teams didn't think we were going to win in Oregon. They laughed at Morgan and Marcus and I. They thought we were too optimistic. And I will tell you, that not guilty verdict, that was on international news. The picture of Kelli hugging everybody everywhere and John hugging everybody everywhere. That went around the world because that victory mattered. That victory not only sent a message, it illustrated a point. And that point is, the day is not lost. The battle's not over. It's still worth fighting. And when we win, and it's hard to win, and victories like that don't come often, but when we win, it makes a difference. It starts adjusting the course and trajectory of what we're doing, of our country. So anyway, there's my free speech for that. It's early in the morning. You have to forgive me for getting a little passionate.
Okay, I have two questions that will take us back to the next trial regarding today's verdict. How does today's verdict impact the next trial? Not as far as the timeline and when it's going to get bumped out, but how does it make you guys feel? Does it impact at all your chances for a win in the next trial? Is it good? Is it bad? Does it not matter?
And from a what's the right way to say this? From a professional and excellent attorney's perspective, everything helps our chances at winning. So, but in reality, I think we don't know. We don't know what it's going to do.
Okay.
We don't know if our trial will be kicked out farther. We don't know if she will consolidate. There are reports that we're hearing that it's replacing our trial on the 26th. There's speculation that they may merge them, which I don't know if that can occur. And
Would you welcome
there's
that?
Also.
Would you welcome that if that did happen?
Sure, I think so. There's also been a statement that came out from the U.S. attorney in Nevada who says they're not sure that they've decided if they will retry. And so I don't know that we can say right now how it's going to affect the June 26th trial date that we currently have. The difficult thing for us as a legal team is we have to prepare no matter what. And when you think about that from a legal perspective, it means the government is forcing us to expend resources almost constantly in preparation for this trial. And then we may get a month, hopefully not a week, out and find out that it's been canceled. And then, of course, you have to contemplate potentially new motions, new issues to deal with in a second trial, new issues that arise out of the first trial. It just keeps us having to be constantly on our toes and constantly at work.
Well, and Kelly, but broader look, it's encouraging that this jury heard weeks and weeks and weeks of the government's case. I mean, the defense case that we didn't have any direct role in. The defense case in this trial, as you know, was a small handful of witnesses. And so it is encouraging that after a jury sits through that barrage of government
garbage.
I want to be polite. That there were enough people on that jury that said, nah, I'm not convicting these people beyond a reasonable doubt. No way. I don't see beyond a reasonable doubt a conspiracy against the United States. Beyond a reasonable doubt, I don't see it for these defendants. Now, there are some concerns. Obviously, the guilty verdicts that came out are very serious concerns. And obviously, some of the things that happened at this trial, very serious concerns. But there is a lot to learn. There's a lot of raw material to use. And I think that's what Morgan says. Everything helps us. The more you know, the more that happens. Time is on the side of truth, generally speaking.
Okay, and then so my other question that I had was, you made reference to you guys representing Ammon and wanting Ammon's story to be told, but isn't it true that by representing Ammon, when you're trying people as a group, since the group has the same message, that what you do for Ammon potentially benefits and helps the entire group? That's what I felt like I saw in Oregon with your guys' representation of Ammon, that it absolutely helped all the other not guilty verdicts. Do you think that will be the same in Nevada, or do you anticipate only representing Ammon?
Well, I think, as an attorney, my job is to represent my client and to seek to represent his interest. But if we see in Nevada what we saw in Oregon, there was a deep desire on the part of the defendants in Oregon to stand together. And I think we're seeing similar, you got family members here standing together in this upcoming trial, with the exceptions of Pete Santilli and Ryan Payne, who are part of the second tier defendants. But I undoubtedly,
second trial, but technically tier 1, right?
Yeah, tier 1, sorry. Second trial, tier 1. I think undoubtedly what we will bring to the table will help everyone.
I thought I seen that as an observer, being in all 3 trials, attending them 3 trials. I seen the first trial where the it seemed like the attorneys there worked with each one of the they mentioned every single one of the other defendants as each one of them was not guilty. And when I seen the second trial in Oregon, that didn't happen. They seemed like each attorney was just trying to represent their own client only, and they never mentioned the other clients not being guilty. And this trial, they did the same thing here. They were all for each individual self and not representing each self. In that first trial, it seemed like Mumford would say all 7 of these defendants are not guilty.
Yeah.
And he was representing his own client, but
I think one thing that I maybe haven't pointed out as expressly as I'd like to is one reason we really need to be in Nevada, and I think it's what helped us in Oregon, is there are a lot of excellent attorneys out there in the world. There are a lot of attorneys out there in the world who will stand on any one particular issue that they feel passionately about. There are a lot of different attorneys who understand a lot of different issues. But contemplate for a moment how difficult it is to find an attorney who understands the issue you're fighting for, who has the legal skills required to fight for the issue that they understand, and who will actually stand on those issues that they believe in the courtroom. That's a harder skill set to find. And if you look at what we bring to the table, that's what we bring. We bring a legal team that understands the issues that we're fighting for. We're a legal team that brings the legal skills required and who actually will go into the courtroom and stand for those issues. And that helps the entire group of defendants who will stand, because it creates a lot of unity. It creates common experience to some degree and common understanding. And I think when you create, or when you pull that type of a team together, it tends to create a scenario where it's a we situation and we are innocent and we didn't do anything wrong. And in fact, what we did was something that needed to be done. And I think that's kind of the message that you began to hear in Oregon. I think it resonated with the jury. And I think that's what we're going to bring to the table again, strategically in Nevada.
You know, John, I have to chime in on that. There are some attorneys in Nevada who are doing excellent work. But, you know, I'm a sports guy, sports analogy. You can take a great player and put them on a team, and it's not a great team, and it doesn't come together. And one of the things that makes it possible for a team to gel is the kind of buy-in. When somebody paints a vision for a strategic vision and says, okay, I got it. Okay, you're going to handle that defendant, you're going to handle that witness, you're going to handle these exhibits, because we're all buying into that same vision. And similarly, you can take a team that's really good, but they don't have a great coach, and they don't play well, but you just change that personality. And I will tell you, one of the things that I think Nevada has struggled with is the way the defendants have been divided up into these camps. And that's what happened in Oregon. You know, the second Oregon trial, I'm unaware of any of those defense teams that ever contacted Ammon's defense team. Now, that was odd. It seemed like, hey, we all together just won, and we played a role here. But see, what happens sometimes is people get used to what you're talking about. Like, they've got their own fight right in front of them. And one of the things we try to do, one of the things Morgan's really good at, you know, Kelli said at the beginning of this, the face of the defense was Marcus Mumford. And it was. And everybody knows that. And Marcus played an invaluable role. But Morgan brings something to the table that doesn't always appear. He doesn't get as much press coverage. He doesn't get as much face time. But there's a dynamic that comes, and he was saying it, about strategy and about willingness to stand for issues, and it inspires confidence in other people to work together. Because I will tell you, Pete Santilli's been doing a tremendous amount of work in preparation for our trial group. The Federal Defender's Office for Ryan Payne has been doing a tremendous amount of work. I know that Clive Bundy, he has the only paid counsel, the Brett Whipple's office. And I know these guys have all been working in their space. And one of the things we're hoping to do as we move forward is to start sewing some of that together, because I do think all these defendants are wanting to stick together. And that's a skill. You know, blending that narrative together is a skill. And quite frankly, you know, it's hard to brag about having that skill because you can't ever predict your results, and you're a hero as long as you win. And then when you lose, everybody tells you you're horrible. But I think that's something by Morgan getting into the case in Nevada, and if the people, you know, who by Morgan getting into that case in Nevada, I think, you know, just whether I'm helping behind the scenes or not, you know, and he really can't tout his own strengths, but I think it increases the likelihood of what you were talking about. I think it increases the likelihood of some cohesion and some unity, and that's important, and some conviction, because clearly all these men have deep convictions, and you would hope that their attorneys did too.
Yeah, I agree.
I hope you might hear some of the things I'm not saying, maybe in between the lines.
That's awesome.
Yeah, and Ammon, you know, the way he operated in the first trial will be the same in the next. That his goal is ultimately always going to be for his neighbor in need first, and he's going to want this next trial to go the same, where, you know, he is a unified team and he knows that nobody is guilty, and so I anticipate it'll play out the same in my opinion as the first trial as far as the unified group. So I'm looking forward to that. We missed that the second trial around. We definitely missed Ammon. We could have, you know, prosecuted him again. I think we would have, just to have him be present in the second trial.
We didn't see that coach, and like you're saying, or that storytelling in the second trial. The first trial, the story that played out the whole time, whoever did it behind the scenes played it very well, and it told the whole story, and the jurors got to see that, and so did we as court observers in there. The second trial, we didn't get to see that, and neither did this last trial that just happened here in Nevada. The unity wasn't there, the coaching wasn't there, and the storytelling really never got finished. We never got to hear the end of the story. In Oregon, we got to hear the end of the story in that first trial. That's why we got what we had, because we knew what adverse possession was when it was done. It was an educational moment for everyone, even the jurors.
Yeah. The government knew a little bit more about adverse possession, I think, when they were done too.
Would you guys be willing to tell us who the main storyteller was in the first trial? Who was doing the majority of the, you know, the motions and the handwriting? Who was the brains behind the words that came out in the courtroom?
So Kelli, I want to interrupt you. John, you have to say those closing arguments, that first day of defense closing arguments, and then the next day when Ryan, those closing arguments, talk about telling a story. I have never felt the way I felt in that courtroom during those closing arguments. And then Matt Schindler's closing argument, Bob Salisbury. Look, Lisa Maxfield's closing argument, all of them. Tina, what was Shauna Cox's defense attorney? Morgan, Tiffany Harris.
I want to say Lisa, but
yeah, no. Lisa Maxfield was Lisa Ludwig was Ryan Bundy. Listen, those closing arguments, I mean, honestly, you could take a recording of those closing arguments and you could transcribe them as a book or a story, and that's what the jury repeated when you asked him, why did you acquit these guys? It was just incredible. I mean, Fabulous Fabio and the whole deal, you know? I mean, it was incredible.
Those closing arguments are what I was pulled out of the courtroom multiple times for multiple reasons, but Schindler's closing arguments actually got me pulled out of the courtroom because she said I was smiling and nodding my head too much. The little short, I don't know what she is, Hispanic or something, Marshall, and I looked at her and I said, I'm trying not to jump over the barricade and give the guy a big hug. I want to commit a crime just so he can defend me. All I'm doing is smiling. So those were good.
Yeah, we've got to do that. We got to give the jury a chance to see the story. I mean, the reason Bundy Ranch is a story so many people in America care about and know is because it is an incredible story. And you've got to fight to get that story out. You can't just
defend their actions. You have to tell the story behind why they did what they did.
Yeah, and you got to find a way to do it. You got to find a way. You know, sometimes a trial is like a movie. And you know how everybody always says the book is better than the movie? Well, that's often true, but there are movies that are so dang good that they move you. You know, they're not many. They're not many. And quite frankly, a trial like this deserves the kind of gravitas that moves people, because there's no other way to win. There's no other way to win against the government. There's no other way.
Yeah. Well, these are issues that really impact so many people's lives, whether they realize it or not. So this really should be played out in a way that in the end of it, everybody's standing on their feet applauding, knowing not only are they happy that the main star won, but they're happy because they also share in that victory. And I think that's what I personally felt with the first verdict.
Just be careful. If you stand and applause, you just might become an unindicted co-conspirator.
Oh, we're there. We're there.
I think adverse possession is going to be bigger than eminent domain before it's over with.
You know, there's a whole other conversation. We should bring Ken Mendenbach in, and when we get Ammon out of prison, when he's found not guilty, we all need to sit down and have another roundtable about the full story of adverse possession, because people do not realize the Bundy family, they are incredible. And I listen, all these defendants are worthy of acknowledgement, but the cause that the Bundy family has stood for is something they've had to learn organically, right? They didn't go to school to learn about adverse possession, but the principles that they hold are so remarkably consistent. That adverse possession theory, that did take some legal strategizing, Kelly. I know, you asked us to disclose who the legal strategizers were, but it did take some legal strategizing, but it was incredible because Ammon's actions were so consistent. Matter of fact, I have to tell you, one of the things that didn't happen in public that people didn't realize is when Ammon took the stand and gave his testimony for those 3 days, there was criticism by the prosecutors in the court that his story was so consistent with those videos that it looked like he'd been coached. And I'm like, and if you know Ammon Bundy, he'd have punched you in the nose for saying that. The reason it was consistent is because it was the truth. And it's easy to be, that's an unusual thing in our day and age, but it's easy to tell consistent stories when your story's always genuine and it's always authentic. And it was funny, you'd play Ammon's video from November and you'd play an interview of him in January, and then here he is in court in October, and it's almost word for word the same, and it's just like, people couldn't fathom that it was because he was telling the truth.
Yeah.
Anyway.
Well, and if I could add to that a little bit, it's important to understand that consistency allowed for us as a legal team to be working on a theory of our defense long before anybody ever heard word of it in the courtroom. And that's important, very, very important. Also, if only you'd heard the entire story of adverse possession, there was a lot that nobody ever got to hear because Judge Brown wouldn't let it into the courthouse. It was too earth-shaking. I mean, truly. And the case law that we could have introduced relative to jurisdiction and land disputes in Harney County going all the way back to 1910 were fantastic. And the research that went into that and the input from our legal team to bring all that forward, you only saw, I don't know, Rick, correct me if I'm wrong, you saw maybe a quarter of what we could have told relative to adverse possession and land rights and jurisdiction in Harney County, Oregon.
Yeah. And that's another thing. You want a legal team that is going to prepare 100% and win with the 25 that gets in. If it's your life on the line, you don't just want one swing at the bat. You want to, you can't get this witness in. Well, I got 4 more as backups. We're going to get one of them in. I can't get that exhibit in. Oh, yeah, well, I got 32 prepared. You can't win that motion. Well, I just filed another one making that argument. People, I'll give you another example. People did not understand strategically, and I'll give, well, anyway, when we did the detention hearing, the pretrial release detention hearing for Ammon up in Oregon, boy, people were so critical of Morgan and Marcus and me and Ammon. Why are you wasting your time? What are you doing? For those who have a brain, you go back and you get the transcript from Judge Jones's interaction with us, with the defense team during that pretrial detention hearing. There were things that happened in that pretrial detention hearing. Everybody's like, oh, we lost. Ammon didn't get out. Yeah, I know. And we wanted him to get out, and we were trying to get him out. But that wasn't the only game we were playing that day. And you need that kind of strategy. You can't always tell everybody what your next chess move is going to be. You got to play that kind of game. And I don't mean to trivialize it, but this is serious business. It's strategy. It's like war, and you don't want to telegraph all your moves.
You don't want to go post them on Facebook?
And sometimes it is tempting to chime in on these Facebook conversations because of all those so-called experts out there who think we didn't know about this statute or this case law. Oh boy, sometimes it's tempting. Matter of fact, I don't know how you've convinced us to do. I don't know if you convinced us or we convinced you, but the fact that it's 2 a.m, I may have to revisit whether we've been wise in participating in our discussion here.
Hey, my name's not Longbow, and I didn't convince you to do this.
And there was no alcohol involved.
Isn't that Longbow thing crazy? I mean, that our government is doing that is so despicable. The America that I grew up believing in, that couldn't exist. That kind of crap couldn't exist in the America I grew up believing in. That's just
what's so maddening. People actually believe that you have the right to remain silent because anything you say can will be used against you in the court of law. But how does that apply if you haven't been arrested yet and you're being set up? Why were all those words they gave to the FBI not first, prefaced with anything you were about to say can and will be used against you in the court of law?
There's another question nobody's asking. It's one thing when law enforcement starts asking you questions or undercover cops start asking you questions. It's another thing when the government has already decided to prosecute you and all of the law enforcement's activities are being scripted by prosecutors. That's a different situation. Look, cops have a hard job in our country and law enforcement has a hard job, but there is no excuse for prosecutors, lawyers, to be kind of behind the scenes kind of telling the cops what to do and basically breaking the law by not admitting the role the prosecutors were playing. I mean, that is Gestapo. That is not free society. Anyway, that's
yeah, and that's why at the end of the day, I know we didn't touch anything on Greg Burleson, and some people were asking what some of the legal side was thinking on the verdict Greg Burleson. But his most damning words were used against him. He was lured and set up to say the things with alcohol and baiting him, thinking he was going to be on a TV show. And how much of what he said was truly what he went to Bundy Ranch with in his heart, we don't know. But the damning words he said against himself were after the fact. And the fact that those were even able to be used against him in court and that it wasn't seen as entrapment. I think
we'll have to have part two. We'll have to have a part two. If this works well, and if the community of folks out there who watch this respond well, even a fraction of how they respond to John's daily reporting, maybe we'll do part two. Maybe we'll do this again, huh?
All right. Well, John, do you have any other questions for him that you saw come up on your live feed regarding the verdict or?
I think that's good for this time. So.
Maybe one thing. A few people have asked why they have multiple gun charges. Why are there 2 gun charges?
There's 2 gun charges.
Actually, it was 3. On the verdict sheet, they were actually stated the same, so they looked like the exact same charge. And I saw people on your live stream, John, asking why they were all the same, how they're charging them with.
Yeah, we need to go through each of the elements of each of the counts, but what happens on those gun charges is there's 2 different decisions that have to be made. And so what the judge has done is prepared an instruction form where they have to answer each question deliberately. But we can talk more about that also, maybe more specifically if people have those questions. Okay. A lot of times the jury's job is a lot harder than you think, and they're given instructions to answer some legal questions. They have to answer distinct legal questions, sometimes more than one legal question related to a particular charge or particular count.
Okay, let's wrap up with this. As far as appealing goes, do you feel like Todd and Greg Burleson have good grounds for an appeal with what you guys have heard? Is that a normal thing to do when you're found guilty and you believe you're innocent?
Well, this is actually kind of insider baseball. It depends on what their attorneys did to preserve their right to appeal. It's a lot more than just coming out saying, hey, I want to appeal. It's what did you do throughout the process. When you think about working a trial in and of itself, there's an entirely other thing going on during the entirety of the trial, which is preserving your appeal. And that's going to depend a little bit on how well their attorneys preserve their right to appeal different parts of their conviction.
One example would be
objecting along the way to things and things like that, do you mean?
Sure, potentially even having filed motions relative to aspects of the judge's rulings they disagreed with, or proactively filing motions to preserve rights or preserve arguments.
Okay.
One of the issues, Kelly, that I saw that should give any defendant a concern is you have a right in America to represent yourself in trial and not to have a government attorney forced upon you. And everybody quotes a real famous case by the United States Supreme Court. It's called the Ferretta case. And you can Google it. It's real easy to find. And if you read that case, the Supreme Court is very clear that the right to represent yourself is a structural right, meaning if it's denied you, it compromises any conviction, any trial, and there are exceptions where you can waive that right. You say, hey, I want an attorney, or you misbehave in such a way. And the landmark case in the Ninth Circuit, you had a guy who was insulting the judge, insulting the jury, threatening to kill the judge, threatening to kill the juries, and even that judge was like, hey, sit down or I'm going to bind you and gag you. And that attorney, that defendant got hauled out of the courtroom, invited in the courtroom, and he still had the right to represent himself. And so one of the concerns that I had is just how the District Court in Nevada viewed that legal principle. I think that should be a concern to any citizen in our country, because that is a high bar. And same with Ammon Bundy, different subject. Cliven's been trying to get an attorney, and I don't know if you guys know this, I don't know if you guys have reported on this, but the Ninth Circuit, Cliven's attorney, Larry Klayman, has appealed like 4 times, I don't know how many times, like several times, and he's lost every time. But just recently, he had filed a petition for writ of mandamus that got denied back in March. And a writ of mandamus is something we can talk about later. It's a very important legal concept. But anyway, the Ninth Circuit just came out with an order just a couple days ago, compelling Judge Navarro and the government to respond to this most recent request for what's called an en banc rehearing for the whole Ninth Circuit to rehear whether Cliven Bundy's Sixth Amendment right is being violated by not being able to choose the counsel of his choice. So that's just one of many, many issues that, even on the surface of this, I think any person should be concerned about, because those rights are big. As Americans, we need to stand up for those fundamental rights. And so that as far as an appeal goes, I think a self-represented party having an attorney forced upon him mid-trial, that's a problem. At least it looks like a potential problem.
All right. Okay, well, thank you guys for coming on here and answering some of these questions, and for everybody watching, I hope you guys follow the trial coming up whenever it is, and come out to Nevada to support these guys and do your part. If you're out of town, you can send financial resources, you can make phone calls, send letters to the defendants in jail, keep them encouraged that way. But either way, we all have a part to play, and these guys here are definitely doing their role, and we're very grateful for it. So thank you guys for everything you did in Oregon and everything you're heading in to do in Nevada.
Isn't there a way to support these guys for Ammon's legal fund? Is there somewhere they can do that?
Yep, you can actually go to bundydefense.com, and that's a great website they've got up and going. You can also go to paypal.me/bundydefense, and you can send any funds to support them, because they're going above and beyond what anybody else has been willing to do. And I believe that they're going to usher us in, God willing, to the next not guilty verdict.
All right, guys. Thank you.